Thank you. Thank you so much. It's really a privilege to be here. I went to Stanford as an undergrad, and my undergraduate advisor is in the room, which makes me very nervous, but I'm thrilled he's here. And I want to thank Michael for inviting me. I want to thank Morgan for organizing everything. Michael, you are very brave to have driven across the Sierra. Just driving here from Berkeley was an adventure this afternoon. So we may all need boats to get home after tonight. I want to open by talking about the moments and days in the immediate wake of the assassination of President Abraham Lincoln. Just 10 days after newly sworn-in President Andrew Johnson issued an order calling for a military trial of the alleged conspirators in Lincoln's killing, the government brought the accused before a tribunal composed of 9 military officers at the old Arsenal Penitentiary in Washington, D.C. The president's order empowered the commission to set its own rules of procedure, and as those rules were promulgated, they provided that a majority vote of the officers could sustain a guilty verdict, and a 2/3 majority vote could sustain a death sentence. The only avenue for appeal was to seek a pardon from the president. Now, appearing for the prosecution in the case was Representative John Bingham. You might know him as the author 1 year later, or one of the lead authors of the 14th Amendment. He argued that the due process guarantee in the Fifth Amendment was, as he said, only the law of peace, not of war. In war, he asserted, it must be and is, that is to say, due process, to a great extent, inoperative and disregarded. By contrast, the lawyer who represented the accused conspirators, Maryland Senator Reverdy Johnson, argued that they deserved a jury trial in a proper court of law. He contended that fundamental liberties are, in his words, more peculiarly necessary to the security of personal liberty in war than in peace. He said, all history tells us that war at times maddens the people. It frenzies government and makes both regardless of constitutional limitations of power. He said, individual safety at such periods is more in peril than at any other. It followed, in his view, that only members of the United States military could be tried by a military commission. Given that the courts were open and operating in the district, the defendants were entitled to a jury trial, he said, with the full panoply of procedural protections set forth in the Bill of Rights. But Bingham wasn't finished. He got back up, and he added that during wartime, in his words, the rights of each citizen, as secured in times of peace, must yield to the wants, interests, and necessities of the nation. Now, as every armchair Civil War historian knows, Bingham's arguments prevailed on that occasion. The military commission proceeded to convict all 8 defendants on various conspiracy-related charges, sentencing 4 of them to death, 3 to life terms, and 1 to a 6-year prison term. Days later, on July 7, 1865, the government hanged the 4 who were given capital sentences. This happened despite the filing by one of the condemned, Mary Surratt, of an overnight habeas petition that reiterated the arguments Senator Johnson had advanced at the trial. Her petition was thwarted by the personal intervention of President Johnson. Just 1 year later, however, and with the Civil War effectively over, in Ex parte Milligan, the Supreme Court rejected the notion that military courts could try civilians in states where the courts are open and their processes unobstructed. In so doing, the court rebuffed arguments similar to those that Bingham had made, and specifically rebuffed the argument that the Bill of Rights constituted peace provisions, that like all other conventional and legislative laws and enactments are silent amidst arms, when the safety of the people becomes the supreme law. Instead, the Supreme Court in Milligan championed the idea that the Constitution of the United States is a law for rulers and people equally in war and in peace, and covers with the shield of its protections all classes of men at all times and under all circumstances. Now, in many respects, the statement I've just read is very inspiring. It makes the Constitution sound very powerful. But the track record of over the course of American history suggests otherwise. More often than not, Bingham's arguments have prevailed when courts have reviewed government action taken during times of war especially, and even more broadly during times of emergency beyond simply war. whether the courts expressly say that the Constitution means something different in such times, or say the political branches deserve extra deference during such emergencies, or say that during such times the judiciary should stay its hand entirely, the result has been the same. In our experience, for all practical purposes, the United States Constitution has meant something different in times of emergency. Indeed, the Supreme Court has regularly permitted the political branches wide discretion to manage national emergencies, even in ways that would be viewed as flouting the Constitution during peacetime. All of this has been exacerbated, moreover, by the ever-expanding conceptions of war and emergency more generally. This being said, there have been a handful of Supreme Court decisions, like Milligan, that have pushed back on the idea that the political branches deserve extensive deference to manage crises. Consider, in addition to Milligan, the case of Youngstown Sheet and Tube Company versus Sawyer, otherwise known as the steel seizure case, in which the Supreme Court told President Truman that he could not seize the country's steel mills that were about to strike during the height of the Korean War. All the same, I will suggest that in most cases arising during emergencies, the court has either deferred to the political branches, delayed deciding important issues, and/or effectively stayed its hand entirely. This is what makes the court's recent decisions during the COVID pandemic and the extensive resulting litigation targeting regulation of conduct during the pandemic that was deemed dangerous to public health so incredibly interesting. In several cases, an emerging Supreme Court majority applied increasingly rigorous scrutiny to government regulations predicated upon public health, and most notably where such rules intersected with, among other things, the exercise of religion, of which Professor McConnell is the expert in the room. So if I get any questions about religion specifically, I'm pitching it over to my pinch hitter. The court was not just active in the realm of religion and in the face of free exercise claims. It was also active in the area of property rights and in ruling on matters pertaining to the separation of powers more generally. It did not apply rigorous scrutiny across the board in the COVID cases. I do want to say more about that in a little bit. But this subsection of decisions, specifically in the religion and property rights context, is very noteworthy for standing in considerable tension with the long-standing track record of deference that historically we have witnessed the court exercise in times of emergency. And for that reason alone, the decisions are worth highlighting and studying, which is what my project aims to do. Now, we have to do some history before we can get to COVID. And we could start in a lot of places and spend a lot of time talking about the court's track record historically. I'll just mention a few key cases. If we go back to the War of 1812 and a case called Martin versus Mott, that case involved the question whether individuals could contest their conscription as militiamen following a declaration by President Madison that a British invasion was imminent. At the end of the day, the Supreme Court held that because the statute was confined to cases of actual invasion or imminent danger of invasion, the question then became, for the court, by whom is the exigency to be judged and decided? To this, the court answered, the president. We are of the opinion that the authority to decide whether the exigency has arisen belongs exclusively to the president, and that his decision is conclusive upon all other persons. This followed for several reasons, the court said, not the least of which was the need to ensure a prompt and unhesitating obedience to the command of a military nature, and also, among other things, based on the fact that the president might have relied upon sensitive information in acting. This set the table for many of the cases that followed, especially during wartime. One of many cases I could talk about from the Civil War is the prize cases. In the prize cases, the court upheld President Lincoln's blockade taken or ordered before Congress had formally declared war. As part of its decision upholding the blockade, the court permitted the president to have decision-making authority over who could be treated as belligerents under the law of war, including, by the holding of the court, persons previously classified as citizens and whom the president had just declared to be traitors. As the court put it in the prize cases, the question whether the president may assign parties the character of belligerents under international law of war is a question to be decided by him, and this court must be governed by the decisions and acts of the political department of the government to which that power was entrusted. In other words, the court was very differential on a very important question of classification pertaining to the individuals in question, in many cases Virginians who were claiming that their property rights had been seized unlawfully. But the judicial deference model, and again, I'm just going to hit a few highlights in the cases that I survey in my work, extends beyond the context of war if we look back historically. And a case of particular relevance to the COVID pandemic is a case called Jacobson versus Massachusetts. In that case in 1905, the court faced the question whether Massachusetts could prosecute individuals for refusing to be vaccinated against smallpox. In an opinion by Justice Harlan, the court upheld the mandate and upheld the power to prosecute in such cases, rejecting arguments that it violated the privileges and immunities of citizens and deprived persons of due process and equal protection. The court likewise rejected a broader argument advanced in the case that the vaccine requirement violated the, quote, spirit of the Constitution. Those arguments don't tend to fare very well with the Supreme Court. In upholding the vaccine mandate, the court said in every well-ordered society charged with the duty of conserving the safety of its members and the rights of, charged with conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under pressure of great dangers, be subjected to such restraint, to be enforced by reasonable regulations as the safety of the general public may demand. In other words, the court deferred almost entirely in that case, and it went on to say it is in no part the function of a court or a jury to determine which one of two modes was likely to be the most effective for the protection of the public against disease. That, the court said, was for the political branches to decide. If we take the story forward and we look, for example, at the Great Depression, we find another Supreme Court decision that is very deferential to the ways in which the political branches decided to confront the emergency. In Home Building and Loan Association versus Blaisdell, decided by the court in 1934 in the midst of the Depression, the court upheld the power of the state against an argument that its actions violated the Contracts Clause to limit the power, or to impose, I should say, new terms on existing mortgages. Specifically, Minnesota had enacted a law in 1933 that permitted debtors to miss payments under certain conditions without penalty during the Depression. The court, with its majority opinion written by Chief Justice Hughes, who once in a speech said the power to wage war is the power to wage war successfully, reasoned in Blaisdell that the legislature may meet public emergencies by action that ordinarily would go beyond its constitutional authority. If we go back to the context of war, we find more interesting and highly deferential decisions. In World War I, we find a lot of decisions by the Supreme Court upholding prosecutions under the Espionage Act of 1917 and the Sedition Act of 1918, including in a case involving a man named Joseph Gilbert, who had been prosecuted and convicted for obstructing the draft during World War I based on his statement that the United States was, quote, stampeded into this war by newspaper rot to pull England's chestnuts out of the fire. The court's deference after World War I continued beyond the conclusion of fighting in a case in which the court upheld fixed rental prices in the District of Columbia that permitted tenants to stay in properties beyond their lease expiration dates. In that case, Block versus Hirsch, Justice Holmes held that a declaration by a legislature concerning public conditions that by necessity and duty it must know is entitled to great respect. If we fast forward to World War II, here we could talk a lot about the court's role in deferring to the political branches, and in no area did it do this more than in deferring to all that followed under Executive Order 9066, issued by President Roosevelt in February of 1942, 2 months after the bombing of Pearl Harbor, As everyone knows, under that order, some 120,000 Japanese Americans, 2/3 of whom were natural-born American citizens, were put in so-called relocation centers. That is to say, they were incarcerated in detention camps. In a series of cases, the court upheld all the regulations that led up to the mass incarceration of Japanese Americans. These cases are Hirabayashi, Yasui, and Korematsu. Hirabayashi is a good example of the measure of deference that the court gave the political branches. In that opinion, Chief Justice Stone said that it is not for any court to sit in review of the wisdom of the executive's action or substitute its judgment for theirs. He went on to write, "We cannot close our eyes to the fact, demonstrated by experience, that in time of war, residents having ethnic affiliations with an invading army may be a greater source of danger than those of different ancestry. This is remarkable for many reasons, not the least of which is this is the same pen that authored footnote 4 in Caroline Products, which was, of course, concerned with the rights of minorities in our constitutional scheme." There is also Korematsu. All I will say here is that with respect to Korematsu, Justice Black, author of the lead opinion, said in an interview at the end of his life that he stood by the decision and would do it the same if he had it to do over again. If we fast forward more recently to the War on Terror, we see more deference. I've written a lot about the Hamdi case. It's a case that involves the question whether the United States government can detain an American citizen on United States soil in military detention without a trial and without a suspension of habeas corpus. Although the broadest arguments advanced by the Bush administration in that case were rejected by the court, it should not go unnoticed that in so doing, the court effectively gave the president a win. As the court held in a plurality opinion by Justice O'Connor, there is no bar, the court said, to this nation holding one of its own citizens as an enemy combatant. Again, without trial, in military detention, without a suspension of habeas corpus. To be sure, if we look back historically, there are exceptions to this deference model. Milligan, which I cited at the outset, is a big example, although it should be noted it came after the Civil War in all relevant senses. Another case, the steel seizure case, which I also mentioned, it is indeed a large rebuke of the president during wartime. But as one of my students highlighted when we were talking about this in class, it is noteworthy that the steel seizure case, say that 3 times fast, is about property. It's not about liberty. Now, all of this backdrop is what makes the COVID decisions by the Supreme Court so interesting to me. Increasingly, as the pandemic waged on, and it bears noting as the court's membership changed in the fall of 2020, court members argued for close scrutiny of government regulations addressing the pandemic, and the court struck down a number of regulations on religious and other grounds. Throughout, in these decisions on close read, we see that several justices specifically opined that deference was unwarranted and the court should not adopt a different model of judicial review, notwithstanding the existence of a global pandemic. Take Justice Kavanaugh in a case called Calvary Chapel, Dayton Valley versus Sisolak in the summer of 2020, a case involving capacity restrictions on religious worship. Justice Kavanaugh wrote, "There are certain constitutional red lines that a state may not cross even in a crisis. They include racial discrimination, religious discrimination, and content-based suppression of speech. This court's history," he wrote, "is littered with unfortunate examples of overly broad judicial deference to the government when the government has invoked emergency powers and asserted that crisis circumstances override equal treatment and free speech principles." In that case, Justice Kavanaugh was in dissent, but soon he would be in the majority. Indeed, mere months later, in the fall of 2020, he was part of a majority that applied strict scrutiny to the New York governor's restrictions on attendance at religious worship in a case called Roman Catholic Diocese of Brooklyn versus Cuomo. Concurring in that holding, moreover, Justice Gorsuch cautioned against a particular judicial impulse to stay out of the way in times of crisis. As he put it, "We may not shelter in place when the Constitution is under attack. Things never go well when we do." In an opinion the following year, Justice Gorsuch added, "Even in times of crisis, perhaps especially in times of crisis, we have a duty to hold governments to the Constitution. Now, adopting a different view and objecting to the court's second-guessing capacity restrictions on religious services during the pandemic, Justice Kagan said that justices of this court are not scientists, nor do we know much about public health policy. Nonetheless, in what she viewed as an alarming turn of events, she complained that the court had taken it upon itself to override the judgments of experts about how to respond to a raging pandemic. Justice Kagan, however, was increasingly on the losing end with these arguments. By the spring of 2021, the court was routinely applying strict scrutiny to limitations on religious worship during the pandemic and increasingly concluded that such limitations no longer survived such scrutiny. This approach also came to pass when the court faced other economic and property rights cases. So, for example, in the context of eviction moratoria, the court in August of 2021 enjoined the application of part of New York's COVID Emergency Eviction and Foreclosure Prevention Act, which, as the court described it, permitted a tenant to self-certify that they are suffering financial hardship in order to avoid eviction. The court then later held that the CDC had acted beyond its statutory authority to issue a nationwide moratorium on evictions in areas especially hard hit by the pandemic, where tenants could make a showing of financial hardship. This is where we see the roots of the major questions doctrine, among other things, and the court would later rely on similar arguments, i.e. that Congress should be the one to decide such major issues when it struck down OSHA's regulation establishing a nationwide employer vaccine and testing and masking set of requirements in NFIB versus Department of Labor. Now, in the lead up to the court's decision in that case and its other ruling on federal vaccine mandates, the court had declined to intervene in several cases arising out of the states having to do with local vaccine mandates. It's interesting that we see, again, Justice Gorsuch making similar arguments as he did in the religious context in those cases. He criticized the court's tendency, he said, in emergencies to take the view that the collective is more important than the individual, and that the demands of an impending emergency were more pressing than holding fast to the timeless promises of our Constitution. Although he was not on the winning end in the particular case in which he wrote that, it is the case that that argument wound up prevailing in quite a lot of cases before the Supreme Court during the pandemic. That being said, as I said at the outset, the court was not uniform in its approach, and it was highly deferential to the government in other contexts, and particularly in the contexts of abortion, prison management, and voting. Even where let me back up, and voting. In the voting context, for example, the court did not side with lower courts that had allowed for drive-by voting or that had done away with witness requirements for absentee voting, all in the name of protecting health. The court refused to defer in those cases to judgments also by political branches. And what's interesting is how the court framed its approach in these cases. So in a case called Andino versus Middleton from October 2020, Justice Kavanaugh joined the court in declining to set aside a state rule that required a witness to submit an absentee ballot, that required a witness in order for someone to then submit an absentee ballot. In his view, the state legislature's decision either to keep or make changes to election rules to address the COVID pandemic should not be subject to second guessing by an unelected federal judiciary, which lacks the background, competence, and expertise to assess public health and is not accountable to the people. Needless to say, this is a very different approach than that which he adopted in the religion context. And more generally, it shows that the court was not entirely consistent in its approach as it conceived of it with respect to its role in reviewing emergency time measures. So what do we make of all of this? I think it's very interesting and noteworthy in and of itself that in some contexts the court was as active as it was. This is because if you were predicting, you would not have expected that, given the track record of cases like Jacobson, Blaisdell, and many of the other wartime cases I mentioned. Now, in approaching judicial review during emergencies, a court could adopt a whole number of different approaches. This includes deference, standing down and not reviewing a case at all. This was Justice Jackson's position in Korematsu. A court could distinguish among different kinds of emergencies. War might be different than, say, a pandemic. A court could adopt an advisory role, like the French Conseil Constitutionnel does, but our courts typically don't do this. Or a court could just say, we're going to call them like we see them, regardless of whether there's an emergency or not. I call this the business as usual model. In my project, I defend that model, the business as usual model, for several reasons. One, and I think COVID really highlights this, people may not agree on whether there's an emergency or not. The most powerful way in which COVID has revealed the problematic nature of what I call the emergency constitution is by underscoring that people may not agree on whether there's an emergency. And if that's the case, there are some really hard questions that we have to confront. If we can obtain broad agreement with respect to whether there's an emergency, who gets to decide? Politicians? Judges? Someone else? And what measure of deference are such decisions then owed by the courts? Even if you assign the decision of whether there's an emergency to a specialized body, let's take, for example, judges, the pandemic showed that there we still are going to see broad disagreement. Let me give you an example: compassionate release from prison. Under the First Step Act, a prisoner can move for resentencing by first making a request to the Bureau of Prisons and then going to federal court. Two questions posed by the pandemic involved whether prisoners still had to go to the Bureau of Prisons before court, and more generally, whether the pandemic warranted an increase in compassionate releases of prisoners. As things unfolded during the pandemic, there were an enormous number of compassionate releases in 2020 and 2021. And for many judges, the pandemic was the key factor driving release. But it was not true for all judges. And if you map the rate of compassionate release around the different areas of the country, you see dramatically different rates of release. So judges themselves couldn't agree on whether there was an emergency in place. And you see similar phenomena when you look at rulings on Speedy Trial Act motions that were made by criminal defendants trying to force their trials during the pandemic rather than have to wait for their criminal trials. Another problem with other models beyond the business as usual model is that, in my view, we have to confront the fact that emergencies no longer have clear start and end points. So the theory of an emergency constitution like that Bingham invoked is this idea that we're going to have an on-off switch, and the Constitution means one thing in peace and one time, another thing in times of emergency. But here one might ask, when is the war on terror going to be over? We seem to still be in it. And as many school children asked as the pandemic waged on, when is the pandemic over? Many of my students still wear masks when they come to class. And if a state of emergency now lingers on and has become, in many respects, our new normal, why shouldn't normal constitutional rules apply? That's the question I would ask. It also is the case, in my view, that history does not suggest that the political branches will self-police for constitutional compliance. And here I would point to the World War II episode of Japanese American mass incarceration. FDR's Attorney General Francis Biddle told him specifically that the detention of Japanese American citizens would violate the suspension clause, the habeas clause in our Constitution. And indeed, the Secretary of War wrote in his diary that he believed the same thing. None of that mattered. When interviewed about this years later, Biddle said, "I don't think the constitutional difficulty plagued FDR at all. The Constitution has never greatly bothered any wartime president. That was a question of law," Biddle said, "which ultimately the Supreme Court must decide." That, in any event, was how Biddle thought Roosevelt thought of these things. Now, as this example underscores, and to be sure, it's a big example, and one might argue it's sui generis. I would not, but I've heard those arguments. It underscores that the political branches, to me, are especially vulnerable to the pressures of war and national crises, and insufficiently sensitive to constitutional considerations during the same. History also suggests, and this same example in particular also suggests, that those managing crises will overreact to perceived threats and or not be fully transparent with the judiciary. The camps housing and detaining Japanese Americans are a great example on this point. There was no factual basis for the policy that resulted. And here I can cite J. Edgar Hoover, who himself, no stranger to infringing on individual liberties, said before the camps were built, there's no factual basis for this policy. It is also the case that when litigating the Japanese American cases, in particular Korematsu, the Solicitor General changed its representations and relied on a debunked report to support the regulations and defend them. So the Department of Justice was not honest with the court about the basis for the policies. I would add that I'm not sure we've learned enough from the past either. And again, this example teaches a lot. I've mentioned how Justice Black did not regret writing Korematsu at the end of his life. Another example, in 2014, Justice Scalia gave a speech in which he said, of course Korematsu was wrong, but you are kidding yourself if you think the same thing will not happen again. Finally, I want to say a word about what I call the perils of adapting the Constitution in emergencies. The idea that the Constitution should mean something different in times of emergency. Beyond the fact that it ignores that our Constitution has express emergency provisions in it, like the suspension clause, in practice, the theory could encompass all provisions in the Constitution, whether emergency-oriented or not. And this raises, if you don't agree with that, it raises huge line-drawing problems. What provisions do we adapt in times of emergency versus what provisions do we hold fast to? If you agree that emergency provisions like the suspension clause and the declare war clause, for example, should not be adapted in wartime, a proposition I hope is not controversial, but might be, what about the anti-discrimination principles in the Constitution? The protection of free speech, the protection of religious freedom? What makes one constitutional principle more foundational and sacrosanct than another? And what would be left of our constitutional identity if we were to water down some of these protections in times of emergency? All of this leads to the final question. What do we make of the court's COVID decisions? They are, I would suggest, a mixed bag. It's possible, and it should be acknowledged, that not all of the justices thought of the pandemic as a full-blown emergency akin to war, and that explains the different approach, particularly in the religion context. If some members of the court did not believe that the pandemic is on par with wartime or the Great Depression, then that certainly explains why they would be more comfortable engaging in aggressive judicial review of some government policies put in place during the pandemic. It is also possible, and Chief Justice Roberts in particular, by his voting pattern, probably subscribed to this view, that as the pandemic continued, the amount of deference certain justices were willing to give the political branches waned. And you can track his votes, particularly consistent with when vaccines were introduced. Then again, there is language in some of the opinions, and I've mentioned Justice Kavanaugh's reference to the court's history being littered with unfortunate examples of overly broad judicial deference to the government in times of crisis. It is possible that some of those justices, like Kavanaugh, really were engaged in course correction and meant to promote a model of judicial review in emergencies that was far more rigorous than historically we've witnessed. But the hard part of deciphering what the court did during COVID is that some of the same justices who aggressively reviewed restrictions on religious worship cited their lack of expertise about health policy to defer to government policies in other realms, like voting, for example. And this includes specifically Justice Kavanaugh. One could argue that voting is a pretty important right. Indeed, as Justice Ginsburg wrote in her famous Shelby County versus Holder dissent, voting is the most fundamental right in our democratic system. And so one could certainly argue that if we were applying normal rules of constitutional and judicial review in times of crisis, any restrictions on voting or any aspects that made voting harder during the pandemic should have been subject to more rigorous scrutiny. Now, to be sure, one might think that the merits pointed in different directions in some of these cases, and I think that explains a lot of what the court did during COVID. But the merits, I want to be clear, pose an entirely distinct inquiry from whether the court should apply the same measure of judicial review or judicial scrutiny during times of emergency as it does during normal times, i.e., whether special deference is owed because of the emergency. Or at least I would suggest that merits decisions or merits considerations should pose distinct inquiries versus the preliminary inquiry of whether the court is going to engage in business as usual. So in the end, I argue that the judiciary would be better to rid itself of its historic practice of deferring in the name of emergencies to the political branches, choosing instead to exercise its role in the same way, no matter what the context. This would have the court members debating out in the open the merits of any case that comes before them, which I think would have been better in a lot of the contexts in which they deferred under the guise of what I really think were merits-driven decisions. The emergency should not matter. And this way, we wouldn't have the court hiding behind shifting models of judicial review that are at root actually driven by a justice's views of the merits. There is some indication by some members of the court that in some cases during the COVID pandemic, they were motivated by a desire to change the court's approach to judicial review in times of emergency. But as I look at the full scope of their approach in the COVID cases, I think there's still quite a ways to go. I welcome your questions.
Folks with questions, please come down in the aisles to the microphones.
Hi, my name's Dave. I'm interested in one of the issues that I thought you might address is, yes, there will be disagreements whether there is an emergency or not an emergency. Then there's also could be disagreements as to what the resolution might be in such a situation. Like today, we see some people would say we have an emergency of rather frivolous homicides in this country via firearms. But does that mean gun control is the answer?
It's an interesting question, and I'm going to come at it a slightly different way because this comes up a lot when we talk about the political question doctrine, which is highly related to what I'm writing about. The questions that come up when we debate the political question doctrine are first and foremost whether courts should address certain legal questions at all, or whether they should stay their hand. And so, for example, some have argued, Justice Scalia has argued that if Congress were to suspend the writ of habeas corpus, no court should check that action, shouldn't review it at all. But we see a lot of courts get nervous about deciding cases in context of war and invoke the political question doctrine not to decide them when what they're really uncomfortable with is the remedy issue. The remedy issue. That is to say, maybe they're being asked to tell the president to stop the change troop movements or change strategy. And in that situation, no court is ever going to issue such an order. And yet you have courts in those cases decide that they can't declare at all, whether, for example, if the president were to declare war or take actions that look like he was declaring war, courts will say we can't say whether that's unconstitutional, even though the declare war clause in the Constitution gives that power to Congress. The problem, as I see it in those cases, and this is analogous to what I'm writing about here, is that courts are nervous about the back-end remedy, and they're using the tail wag the dog, as it were. They're using concerns about remedies at the back end to shore up an excuse not to ever decide the question in the first place. And so there's an analogy to be drawn there. To the extent that more generally you're asking about what the right remedy is in a case of particular emergencies, naturally there would be a conversation between the political branches and the courts about that. It is interesting that you brought up the case of guns, because I teach a class, I'm teaching it right now on the Constitution in wartime, and one of the assignments I give out to my students is an assignment that lists all the emergency powers that the president has, understanding delegations from Congress. And it is quite a long list, to put it mildly. My students and my children are horrified when I tell them, among other things, if the president declares an emergency, he can turn off their cell phones. So it is interesting that in light of that, for example, in the context of mass shootings, no president has ever invoked that or called that an emergency as a predicate for invoking emergency powers. Because one could imagine, given the other examples, and you can look at just what FDR did with respect to the banks during his tenure, there's certainly an argument to be made that the president could potentially invoke emergency authority with respect to the school and mass shooting phenomena in this country.
Hi, thank you so much for the talk, and sorry if I cannot speak loudly, I'm recovering from a cold. So my question is, what are your thoughts about the following? In my view, the COVID pandemic exposed a new form of intolerance. So the United States was formed around the First Amendment protects against religious intolerance, but it exposed the fact that because the CDC said this is the science, many institutions, including Stanford, suppressed their own commitment to the scientific method. They condemned Scott Atlas, Jay Bhattacharya, who were actually right in asking questions and reviewing the research. The fact that a single CDC recommendation was used to shut down schools, and that this is an actual threat that we are going to face more in the future, so-called medical tyranny, for lack of a better word, I don't know how to call it, but this notion that a government entity like the CDC says such, and this has to be taken as truth as the Vatican, and therefore every single possible abuse of civil liberties can be justified because the CDC says so.
Well, I mean, I think your question gets at the more fundamental question of who decides and whether if the political branches or government agencies decide that science points in a particular direction, that's subject to any second guessing, not just by the people, but by the courts, which is what I'm talking about. And there are hard questions that come up with respect to the scientific aspects of these questions. But what I would say more generally, stepping outside the COVID context, is it's not like there aren't hard scientific questions that come before courts in other contexts. That's why we have expert witnesses, for example. That's why we have various approaches to deciding, take, for example, a patent case, right? Courts do this. Some work might be a little bit harder. It might require a little bit more work. It might require some fact-finding. But courts are equipped to do this. And it's not obvious to me that just because science is involved, for example, courts should run for the hills. Now, I want to be clear that in writing about the COVID cases, I didn't go through every twist and turn in my talk. There's not time, and you probably don't want to know every twist and turn of every case. But some I think the court got right, and some I think they got wrong, and I tend to actually disagree with a lot of the ones that they decided in where they struck down provisions and flip on the others. But that's not what's driving me to write this paper. It's not, for me, it's not about the merits. It's about the court's approach. And we can have a disagreement or a discussion about the merits of some of these cases, but what's interesting to me is that there are members of the court that are saying we should be doing this, we should be following this business as usual model. And if that's the case, then whether science is involved or something else, the courts should operate like they ordinarily operate. And to the extent that there is a case to be made challenging some aspects of policy, then make it in the good old-fashioned way. I always come back to, and maybe too much, but it's because I'm writing a book about it, World War II and the detention of Japanese Americans. If you look at the Korematsu case, Justice Jackson writes a fascinating opinion that can be cited for just about every proposition, because he says, among other things, we shouldn't decide this case, but we're deciding it wrongly, which is a really interesting approach. One of the things he highlights, apropos of this larger point, is that there had never been a trial with any fact-finding about the underlying circumstances allegedly justifying all the restrictions that followed under 9066. And he says, this is a little bit curious that we're just taking it as a given that Japanese Americans were spying. And it turns out we know, and in fact they knew at the time through various government reports, that was not the case, and there was no evidence for it. So that's another example of where I would say we shouldn't just take the government's word at face value, especially when we do have constitutional rights of individual liberty that are being infringed.
Thanks.
I guess it bothers me a little bit. We can agree that there's wars that make more, there's more at stake in war A, B, C. Mm-hmm. So if Putin says, right, he shoots a missile, you don't want a constitutional question, but gee, let's get the Congress together and declare war. So why couldn't you have, in the cases where a pandemic is worse than the other, in the cases where it is worse, and there is much more agreement, World War II is more important than Korea, et cetera, why wouldn't in that case you allow more deference to the president and political actors who are more familiar with the situation? I don't think the military and others, I don't believe they briefed the court.
So once again, my professor is calling on me. I took a number of classes with Professor Brady as an undergrad here. I think it's important to differentiate when we talk about war, that there are some questions that are not subject to judicial review because the constitutional plan commits them completely to the discretion of the president. And that is an important thing to bear in mind. Now, I have been, in my scholarship, critical of the political question doctrine, but that's a doctrine that says, oh, there are, at least at its broadest reaches, there are limits, but we're not going to enforce them as a court. That's not what I'm talking about. If we're talking about strategy, troop movements, no court should be ruling on the propriety of that, because there's nothing in the Constitution to be enforced with respect to that, at least at first blush. I mean, if there's a contrary argument, then that would be different. So it's really important to understand, and this goes all the way back to Marbury, where John Marshall, Chief Justice Marshall writes, there are questions that are submitted is his word, to the executive for resolution and subject to the discretion of the president under the constitutional plan. In that situation, there's nothing for a court to do. But at the other extreme, if the government takes actions that do cross the boundaries with respect to specific enumerated constitutional rights and individual liberties, that's sort of what the courts are there for. In many respects, that's what Caroline Products was about. Footnote 4, Chief Justice Stone says there are certain groups in this country, minorities, that are not going to have enough political power to have their interests preserved through the political process. And that's what makes it so ironic. He's defending judicial review in that opinion, that he then writes Hirabayashi and says, oh, well, they said they've got to lock all these people up. It doesn't matter that they're Americans. That's fine. We have to defer. So, I do think there is a line there between areas where discretion is assigned to the political branches on how to manage war in a lot of specific respects, but there are limits on that. And particularly when you think about individual liberty and you think about the fundamental defense of judicial review, James Madison, in introducing the Bill of Rights, said the peculiar guardians of these provisions are the courts. It's an interesting...
So just suppose that there's all kinds of terrorism going on.
Okay.
It's happening on a regular basis. Surely that's different. You might see in that case, you might want to suspend some rights because there's a tremendous amount of death, and you might not want to wait 3 months or however long it takes the courts to decide.
You might not, and I would say in that situation the Constitution has some emergency provisions in it. You use the word suspend. We have the suspension clause, which if you understand it to mean what Lincoln said it meant, and his understanding, I'm going to put a star footnote and come back to the star footnote, but his understanding was consistent with the English model from which the suspension clause derived. The understanding is that if you have the power to suspend, then you can, in fact, detain individuals. But there needs to be, as we wrote into our Constitution, an invasion or rebellion. Things need to be really, really bad, like Civil War level bad. We've only had 2 suspensions as a federal matter outside of territories in American history, Civil War and Reconstruction, the latter to combat the Ku Klux Klan in South Carolina. Now, it's an emergency provision that's included in the Constitution in part to address where things might get really, really bad. But it was limited because the founding generation had seen that over the course of British history, that power, that very dramatic power, had been abused. And so it was constitutionalized, and limitations were put in the Constitution that suspension could only be invoked in rebellion or invasion. That's one example of where the Constitution, which some might say is rudimentary and hard to amend. Bruce Ackerman called the suspension clause rudimentary. It is hard to amend, and it is. Those are why people argue for adaptation. That's one of the lead arguments. But there are emergency provisions in there. They may not be enough, but that is certainly one option if things are that dire. Now, another thing to keep in mind, though, is that the president does have a lot of immediate emergency powers under the constitutional scheme to repel invasions, among other things. And so, and certainly one would acknowledge that if Congress couldn't meet, if it was physically unable, one of my students raised the example last week of, during January 6th, in real time, Congress, for at least a period, literally could not function. So if you have that situation, well, then it is a different scheme. Because if the wheels of the constitutional structure cannot literally operate, then we're starting to look like we're in a state of martial law, and it's a very different set of affairs. The question that I would always ask in any hypothetical of an extreme emergency is it really that dire? Is it really the case? And I take that to be the question the court poses in Milligan. The courts are open, they're functioning. There's no reason this individual can't be tried in the ordinary course.
I had a question about the business as usual model. It seems to me like there's 2 ways that could play out. One is courts apply constitutional doctrine as it already exists. The second is that courts rewrite the rules out of a sense of perceived necessity and then say, that's the new business as usual. And the New Deal might be a good example of that. You could read the constitutional transformation there as stemming from the court's reluctance to say, this falls under the emergency powers doctrine we came up with in World War I. And as a result, they end up transforming Congress's commerce power, taxing power, spending power, in ways that, for better or not, are just more transformational to the structure of the American Constitution than it might have been to say you're allowed to take certain measures in times of emergency.
That's a great question. Do you want to ask yours, and I'll try to address both?
Sure. So thanks for the research that you shared with us. Just as one possibility I'd like to hear your thoughts on whether or not to make sense of the 2 different approaches that Justice Kavanaugh was offering in terms of different levels of deference, it seemed. Across American history, we often differentiate between different levels of rights, political rights, civil rights, and natural rights. Some are seen as more fundamental than others. Some are held by members of the political community, some by a much broader population. Do you think it's possible that perhaps the court can be, there's a way to make sense of this, that the courts could be more deferential, let's say, to the political branches in times of emergency if they're suspending political rights, let's say, but more fundamental ones, like, let's say, the free exercise rights, which aren't necessarily political rights, there they do need to be more deferential.
Yeah, so two great questions, and I know we're running up on time, so I'll try to be efficient. Okay, thank you, Michael. It is interesting to think about whether we have a hierarchy of rights, and that is a big question that comes up when we talk about the Constitution in times of emergency. Are there some rights that are more important than others? In international law, we know during emergencies there are certain rights that you cannot derogate. And so they have, under the international law framework, carved out, there are certain things you just can never do, period. These rights are super special. And yet, we certainly don't obviously have that in our constitutional scheme. And the question then becomes, but we might see it in practice, and we might imagine a situation where we might defend that. What I find curious about the distinction between political rights and other rights is that if you think about political rights, and I don't know whether you would classify voting within that, but I would come immediately to talk about voting. To the extent that we're not making voting accessible during the pandemic, for example, there was one gentleman that testified about the drive-by rule. He said, I'm sick of, he was a black man in the South, and he said, I thought the days of having to risk our lives to vote were over. I don't want to have to risk my life. I'm immunosuppressed. I'd like to do a drive-by vote. And the court threw out that accommodation and said, the legislature didn't provide for it. We can't second guess that. They know better. What I question about that is that if the court is going to stay its hand, then we are naturally assuming the political process will protect rights. I mean, that the political process is going to have the final say. But if we're not making it easy and accessible to vote, then why are we believing in the political process? That's the main reaction I have. Now, as to the interesting question about changing the scope of the law in emergencies, that is a really interesting question, because most of the people who write about emergency constitution and defend the proposition that the Constitution should mean something different in times of emergency. I'm thinking of a piece by Mark Tushnet called Reconsidering or Defending Korematsu, which is a very provocative title, to put it mildly. I taught it this week, and he says, everything will go back to normal after the emergency. We'll make amends, we'll learn from our mistakes, we'll realize that we can do better. But instead, because, and your question is getting at this, sometimes the emergency triggers an actual change in the law, we wind up living with those changes. We don't self-correct at the end of the emergency. And what I would say today, when we think about the war on terror in particular, and we have these emergencies that just go on and on and on, that exacerbates all of these problems. And it's what brings me back to the business as usual model. I don't know if I've convinced any of you, but I've had a great time being here, so thank you.